is present.
My Lord, the claimant is in court. Victor Hasiri.
Any of the defendants, represented?
The first defendant is absent, my lord.
Sorry?
The first defendant is absent.
My lord, the second defendant is unrepresented.
My lord, the third defendant is also unrepresented.
Appearances?
With due respect, my Lord, Chief Paul C. Obi. My Lord, I appear for the claimant, and appearing with me is my learned friend, Ozioma Ihe Agwam Esquire. Ozioma Ihe Agwam Esquire, my Lord, for the claimant.
May it please the Honorable Court. R initial. R Ekobedefe, my lord. R Ekobedefe, my lord. I'll spell EKPOBEDEFE, my lord.
Yes.
FE, yes, my lord. My humble appearance is for the first defendant. I appear with my learned colleague, Elizabeth Olojede. We appear for the first defendant, my lord.
Yes.
May it please this honorable court, O.R. Ojigoro. My lord, Ojigoro is spelled O-D-J-I-G-H-O-R-O, appearing for the second defendant.
May it please the court. My name is Mercy Ariowodion, spelled as A-I-R-I-O-H-U-O-D-I-O-N. I appear for the third defendant.
Yes.
My Lord, the matter is slated today for adoption of final written addresses, and subject to the convenience of the court, all the addresses are in, and we are ready to adopt the same, my Lord.
Yes.
Yes, my lord. From our records, we have a pending application to regularize our reply to the claimant's final written address. I was absent at the last adjourned date because I was not informed of the last proceedings. I didn't get the Zoom link. However, I spoke to the second defendant's counsel, and she informed me of the last proceedings, and that the claimant had regularized his own final written address.
Yes.
Our pending application is dated the 30th day of November.
Your application was considered at the last adjourned date. Your application was considered.
And adopted.
It was considered because as at the last adjourned date, your time started to run.
As court pleases.
Recollect. The reply on point of law. You are talking about your reply on point of law.
Yes, my lord.
The reply on point of law filed by the first and third defendants are deemed to be properly filed and served.
As
So
court
what
is
you need to
most
do is
grateful.
to withdraw that application for extension of time.
Okay, my lord. Giving the directive of the Honorable Court, we hereby withdraw our application for extension of time dated the 30th day of November 2023.
The application is hereby struck out.
As the court pleases.
As the court pleases.
Yes.
But my lord, I guess the first defendant will have to adopt first, since they are the first on the line.
Yes, my lord. The first defendant filed first, and by the rules of the Honorable Court, the second defendant also adopt first. So we thank permission of the court to proceed with our adoption.
Yes.
My lord, the first defendant's final written address is dated the 21st day of July 2023 and filed on the 25th day of July 2023.
Just a minute. Let me. It's filed when?
On the 25th day of July 2023, my lord.
It's dated.
It's dated the 21st day of July 2023.
And it's filed
On the 25th day of July 2023.
yes.
We adopt all our arguments contained in our final written address, and we urge the court to dismiss the claim of the claimant with substantial cost. My lord, may I be guided by the court with respect to our reply? Should we adopt the reply, or we wait for claimants to adopt his and thereafter we adopt our reply?
I would prefer that you wait for the claimant.
As the court pleases. And my lord, will we be allowed time for adumbration with the kind permission of the court? oral and
I'll
operation.
give you, this is virtual. I'll give you 5 minutes.
As
You're
court,
done
please.
raised.
Yes, my lord. By way of an operation, my lord, just simply to point to the fact that the claimant basically seeks declaratory reliefs in his claim against the first defendant. And we submit that the claimant has been unable to prove on preponderance of evidence the claims he seeks against the claimant. We first start with the issue of the dismissal of his dismissal from the employment of the first defendant. My lord, the claimant's assertion is that he was never dismissed and that his termination was as a result of his resignation. However, my lord, if the court looks at all the evidence put forward by the defendant, as well as the oral evidence of the witnesses, the court will see that the claimant was subject to a disciplinary committee on account of fraudulent malpractice. The claimant himself attended the disciplinary hearing, had the opportunity to make representations, and even in one of the hearings admitted to being aware of the fraudulent malpractice, which is the reason why he was dismissed from the employment of the defendant, of the first defendant. Furthermore, my lord, the first defendant is under a statutory duty to report to the Apex Bank, which is CBN and the third defendant in this case, where such events occur that leading to termination on account of fraud or misconduct. The first defendant, in keeping with this duty, reported that the claimant's employment has been terminated. Furthermore, 2 years later, after the termination of the claimant's employment, the claimant kept requesting that his employment be reinstated and further requested that he should be allowed to continue with his life. It was on the basis of that, my lord, that the first defendant listened to the claimant's appeal, set up an appeal committee, and agreed to commit the claimant's dismissal to a resignation. So, my lord, the point being made here is that the claimant's contention that there was no dismissal is false and misleading. My lord, there was a dismissal. It was 2 years later that the first defendant magnanimously decided to temper justice with mercy and allowed the claimant to resign so that he would be able to continue with his life. Also, my lord, even after committing his resignation to his dismissal to resignation, the first defendant went further to inform the third defendant of the recent status of the claimant, that he's now been allowed to resign, and based on the appeal committee's finding that he was found negligent and not of fraud. So the first defendant communicated that information to the third defendant, my lord. Also, my lord, the claimant is claiming special damages and special damages for loss of employment. My lord, we briefly need to call the attention of the court to the claimant's LinkedIn profile that was tendered in evidence. Part of the claim of the claimant is that he's entitled to special damages for loss of employment. And Lord, no evidence was tendered by the claimant with respect to his inability to secure a job. When he was confronted with his LinkedIn profile, which showed that he had worked for over two companies since his exit from the first defendant, his response was that he was not being paid. But my lord, they did not tender any evidence before this court to show that he was not being paid. His salary was not tendered. His account statements were not tendered. The contract of employment also was not tendered. My lord, we submit that the claimant has not been able to furnish enough proof to back up his claims for damages or even special damage. Lord, we submit that the entirety of the claimant's claim is without any proof and should ordinarily be dismissed by this honorable court. The court be dismissed.
àjọ tó ń rí sí ọ̀rọ̀ ìṣòwò ìlú lọ́pọ̀ ọdún orí ìlú ẹ̀ ìtàsílẹ̀ kò tẹ́ni lọ́rùn tó sì tó ṣe pé láti tajú.
Yes, can you hear me?
Yes, my lord, you can hear you.
Yes, my lord.
We have a problem with our connection, which we have been trying to sort out, which is very unusual. Yes. Yes, Arekobe Defe.
Yes, my lord.
Yes.
Yes, my lord. I just want to touch on a few points.
Because of the connection problems, I think I will not, I'm sorry, I can't allow you adumbrate because there are so many other parties. So just go ahead and adopt because we have problems with the connection.
Most grateful, my lord. That's
why I gave you 5 minutes.
Yes, my lord. My lord, we adopt our final
yes,
written address.
You have already said that, yes.
Yes. Dated the 21st day of July 2023, and we urge the Honorable Court.
Okay, you're asking that the suit be dismissed with substantial costs.
Yes, as the court pleases.
Okay, all right. Yes, second defendant, please. That is O.R. Ojigoro.
Yes, my lord. My lord, we filed our final written address dated the 4th day of October 2023. Wherein we raised 2 issues for consideration.
Yes.
Yes, and we have raised copious arguments in support or addressing those issues raised. And on the basis of this, and in light of all the evidence we've tendered, we urge your lordship to discountenance the arguments and the relief sought against the second defendant, and we adopt our final written address as the arguments in favor of the second defendant.
Yes.
My lord, I'm guessing the same would apply. Would we be allowed to adumbrate, or because of
1 minute? If the connection goes off, you just have to wait for them to reconnect. We're having problems. Just
Yes,
one
my-
minute adumbration, please.
Yes, my lord. My lord, the case against the second defendant is very simple. It is whether the second defendant should be punished for following its contractual, the statutory and regulatory requirements that was placed on it. Contractual being that by basis of the contract of employment between the claimant and the second defendant, the claimant's employment was conditional upon the approval of the third defendant. Statutory being that by the provisions of the BOFIA as well as the CBN Act, every bank is required to submit the names of new employees to the CBN, and where it receives an adverse report, it cannot continue with that employment. That can be found in section 47 of the BOFIA. And regulatory being that the third defendant, as the apex regulatory agents, as the apex regulatory body in Nigeria overseeing financial institutions, has the right to be aware of everything that goes on in the banking industry. And pursuant to this, had issued a circular mandating all banks to submit the names of new employees to it. And where it receives an adverse report, should not proceed with that employment. On the basis of this, the second defendant had complied and had forwarded the name of the claimant as well as others to the third defendant. However, it received an adverse report only against the claimant, stating that it could not proceed with the employment of the claimant, because the claimant had been blacklisted. And that is just the basis of the entire argument. The second defendant had complied with that requirement.
I've said that before. I am watching the technology, please.
Yes, my lord.
Let's round up, please, so that the next counsel can go on.
Yes, my lord. The only other argument that the claimant has made is that when his name was delisted from the black book, he ought to have been employed back by the second defendant. And to this, we've said that this delisting had occurred almost a year after his initial termination, and it would be unwise to expect that the second defendant was required to keep that position vacant for over a year without even knowing whether or not he will ever be delisted.
Yeah,
and my lord,
can I hear the third defendant, please? I gave you 1 minute. Yes. The
third defendant's final written address is dated 3rd October 2023, but filed on the 6th of October 2023. The third defendant raised one issue for determination for this honorable court.
Yes.
Made arguments in support of the issue. My lord, this thing is that the claimant has not made out a reasonable case against the third defendant, and all arguments are already contained in our address. In order not to waste the time of the court, we will not be speaking further. We will be adopting our address, adopting our arguments as contained in our written address, and urge the court to dismiss this action against the third defendant. We qualified the reply, but we'll be doing that after the claimant has adopted his final written address.
Yes, Chief Polobi.
My lord, for the claimant, we filed a final written address dated 15th of November 2023 and filed on the same day. The same was regularized by your lordship on the 9th of January 2024. In the final written address, my lord, we formulated 2 issues and we canvassed arguments on the 2 issues. My lord, we adopt the issues formulated and the arguments canvassed in this matter in urging your lordship to grant the prayers and reliefs of the claimant against the 3 defendants in this case. My lord, the claimant's case is quite simple. He was employed by the first defendant, and for no reason, no justifiable reason, because of a malpractice that occurred while he was on vacation, the first defendant dismissed his employment for fraud and notified the 3rd defendant of that dismissal for fraud. Unknown to the claimant, he got another employment with the 2nd defendant, who sent letters to the 3rd defendant for background checks, and it turned out to be negative that he was dismissed for fraud by the 1st defendant. And while the claimant agreed with the 1st defendant that his termination should be for resignation, and he actually resigned, the 1st defendant wrote back to the 3rd defendant, instead of telling them he was terminated by resignation, told them he was terminated by negligence or for gross negligence. And so immediately the report got to 2nd defendant, his employment with 2nd defendant was summarily terminated. But no, our position is quite simple. This is a man who has spent all his life in the banking industry. And by this singular act, he has become unemployable in the financial services industry. Even the 2nd defendant under cross-examination and 3rd defendant confirmed that for someone dismissed or terminated for gross negligence, they will not employ him in their establishment or organization. My lord, the issue is quite simple, and in response, by word of adumbration, my lord, to respond to the argument of the 1st defendant in adumbration, we simply tell your lordship that the address of counsel, no matter how brilliant, cannot take the place of facts or evidence. In this case, the submission that the claimant was aware and admitted that he was aware of the malpractice is not born out of evidence. There is no evidence to suggest that he was aware of that malpractice. He was on vacation. Evidence abound on that. We have laid credible evidence on the facts of this case, my lord. Secondly, on the argument that he was dismissed and in tampering justice with mercy, to quote her, another friend said they commuted the dismissal to resignation. The question then is, if you commuted his dismissal to resignation, why did you not notify the 3rd defendant that his termination was by resignation?
You follow me. Time you have to, so that I can take
as the court pleases. But not, and then finally,
because we're having technology problems here.
Finally, my lord, on the issue of LinkedIn, evidence is before your lordship that the claimant, since he left the employment of the 2nd defendant, had never been employed anywhere, paid employment. We urge your lordship, my lord, to consider the case of the claimant on its merit and be sympathetic with this man who has lost every hope of having a gainful employment in his career. He's at home doing nothing, can't pay his children's school fees, can't pay his house rent, has to depend on friends and family after spending all his life in the banking industry. And the 3rd defendant said, if the 1st defendant had informed them that it was by resignation, his name will neither be in the black book nor in the miscellaneous register. We urge your lordship to disbelieve the stories of the defendants and direct them to order and correct their records. And he knows that he left the banking industry by resignation and not by dismissal or by negligence, and to grant him the special damages we have pleaded and proved before your lordship. because he's entitled to it. His career has been ruined by the act of the first defendant. We urge your lordship, my lord, to grant the relief sought and enter judgment in favor of the claimant. We're very grateful, my lord.
Yes, can I hear our?
Yes, my lord. We filed reply address.
So that I know that I didn't hear much of you from your address, but go ahead and Adam Bridge to reply.
My lord, we filed our reply address. Unfortunately, my lord, it's not dated, but it was filed on the 30th day of November 2023.
It was filed when?
30th day of November 2023.
Yes.
Yes, my lord. We have asked arguments in support of our position and in response to the claimant's final written address. Arguments are contained therein, my lord, and we adopt same in urging your lordship to dismiss the claim of the claimant. My lord, by way of adumbration, my lord, not to belabor the court with too much talks. My lord, we have, during the trial, my lord, we tendered various documents, including the appeal committee's reports, wherein the claimant himself admitted that he was aware when he was confronted by his colleagues.
Have you muted yourself?
I'm so sorry, my lord.
Okay.
However, my lord, the claimant himself admitted, I can't get the name of the expert right now, admitted to being aware of the malpractice, which is the basis upon which his employment was terminated. Also, my lord, upon agreeing to commit his termination, its dismissal to resignation, the first defendant wrote to the third defendant, having previously informed the third defendant of the status of his termination from the employment of the first defendant. The first defendant is under a duty to also inform the third defendant circumstances surrounding his committal to resignation. His committal of dismissal to resignation, my lord. The claimant expected that the first defendant would just inform the Apex Bank that the claimant's termination had been committed to resignation. However, my lord, the first defendant is duty bound to also disclose the circumstances surrounding his committal to resignation, which is what the first defendant did, my lord.
I want to hear your adumbration on your reply on point of law, if you have any.
Yes, my lord. With respect to our reply, my lord, the claimant has been unable to prove his case before my lord. All the claimant has relied on are perceived admissions, which cannot take the place of proof when it comes to declaratory release. We rely on the case of Aja and Okoro, 1991, 7 Nigerian Weekly Law Reports.
Is it in your reply? It's in your reply
Yes,
on point of law.
Yes, my lord. This is also in our reply on point of law. Also, my lord, the claimant has been unable to furnish the court with proof that he was exonerated of the charges of the claims against him when he appeared before the appeal committee, as well as the disciplinary committee, my lord. There's no proof before this court that he was exonerated. And therefore, my lord, his claim that he was exonerated cannot stand. Also, my lord, on the issue of whether the claimant had been employed, gainfully employed after his termination from the office of the first defender, my lord.
We're looking at reply on point of law.
Yes, my lord.
Of law.
Yes, my lord.
Council is re-arguing her address.
That is why I am guiding her. Reply on point of law is what.
As the court pleases.
If you don't have any reply on point of law only, that is what you are doing now. On point of law only.
Yes, my lord. My lord, the principle is he who asserts must prove, and our position is that the claimant has not been able to prove his assertions. We urge the court to dismiss the claim of the claimant with substantial force, my lord. And the court pleases.
Yes.
My lord, it's not defendants.
Yes.
Well, it's not defendant's reply on point of law. It's dated and filed on the 24th of November, 2023. Dated 24th November, 2023, and filed on the same day. It contains arguments in response to the claimant's submissions. Of the court to hold that the claimant has failed to make any case against the third defendant and has not mentioned to this court any wrong that the third defendant has done warrants the claims against the third defendant. We therefore urge the court to consider the totality of this case from the pleadings to the evidence led at trial and dismiss this case with substantial costs against the third defendant. In favor of the third defendant, my lord.
Yes.
Ask God, please.
The second defendant, did you file a reply on point of law?
No, my lord. I didn't file.
My lord, we did not file.
March 6 for judgment. March 6 for judgment.
As the court pleases, my lord.
The case is adjourned to March 6, 2024 for judgment, which will be delivered virtually.
The court pleases.
Details of the virtual hearing will be sent to council and published on the virtual course list.
As the court pleases.
The court pleases.
As the court pleases.
Court will rise.